Violation of competition law can lead to high fines, long battles, and reputational damage. As mentioned in the last presentation, a victim can also seek damages. The competition law has only two bans directed at the business sector, a provision concerning the ban on abuse of dominance and a provision concerning the ban of anti-competitive agreements. So it should be easy to stay compliant. However, breaches are often made in the heat of the battle, so to speak. And breaches can be made by anybody in the organization and anyone in the business group. Having a compliance program can help one organization identify and avoid practices that are in breach of competition law, saving time, resources, and reputational damages that would result from a competition case. We are fortunate here to have a man with in-depth knowledge on this very topic and in the competition law in general. He has authored the books Konkurrenseretten and In Between Regulation and Deregulation, and has also co-edited the book Tilretten. He has published extensively on a broad variety of topics in competition law and sector regulation. Please welcome Professor Christian Bergqvist from Copenhagen University.
Mentioned I'm also on YouTube. Now, when I got the invitation to talk about compliance, I was also asked to provide a title, and I chose the title, Why Does Good Company Misbehave and Infringe Competition Law? Because, as I shall explain shortly, most company actually want to be compliant, but obviously mistake happens. And then I start thinking about preparing my presentation, and when I did that, I kind of realized it was actually a subject that I have feelings about, because one of the first tasks I was assigned fresh out of university 24 years and 25 kilos ago was actually drafting a compliance program for the Danish postal incumbent Post Denmark. And those of you who work with competition law knows I have completely failed, because that company had unbelievable many competition infringement. So I suppose that the real title of my presentation should be, Why does company that knows better misbehave, or should know better, misbehave and infringe competition law? And I think one of the explanations of that is that there is a misconception. It should, in principle, be easy to be compliant. As explained, there's only two provisions. Don't do anti-competitive agreement. Don't abuse your dominant position. But in reality, things are different. Moreover, our interests are actually aligned. I'm a consumer. I do not want to be victim of a cartel. You know, you're an enforcer. You don't want to be unemployed, but you would prefer not to have so many infringement. And if you are a company, you do not want to get into a cartel with the consequence of getting involved in litigation, and claim for damages, which just simply grabs on and on and on for years, and the only one who really benefit from it is the lawyers. So, I don't want to say anything unfavorable about lawyers. I understand we have a lot of them here. So the point is, why is it that if all our interests are aligned, we nevertheless repeatedly see infringement? Thinking about my own failure, I think it goes back to a couple of misconceptions. And I also, thinking back about that compliance program I did 23 years ago, I actually think I also was guilty of these misconceptions. And misconception number one is that it is quite normal to engage in cartel activities. You know, companies love to gang up and inflate prices. That is at least the picture you get when you listen to people like me, or you go through the media. And once again, I'm guilty. The Danish newspaper Børsen has a story today about the financial sector, and I'm cited, and I might indicate that there is a competition problem, which I actually believe there is. But the point is that the narrative most have and most peddle is that there's a lot of infringement out there. And make no mistake, we do have infringement. On the right, you can see some hidden camera from the infamous Lucene cartel. The federal FBI infiltrated the cartel and managed to take a lot of very embarrassing pictures and film. They are all on YouTube. I recommend watching them. They're quite entertaining. It is very embarrassing to see adult men tarnishing each other and the customers and the enforcers like that. If you don't want to go to YouTube, you can just turn on to Netflix, Informant. It's highly recommendable. It is very entertaining. It's with Matt Damon, and that is a movie about the Lucene cartel. And if you see the YouTube video or you watch the movie, you have the feeling that there are so many cartels out there. You don't need to turn to Hollywood to see cartels. We got a Danish movie about electricity cartel from the 90s. Once again, it is a true story. The movie is relatively faithful for the real story, except the ending. It has a Hollywood ending. The criminal goes to prison, and he lives on. In reality, everything went wrong. The company collapsed, and he had to migrate. Even the wife left him. So it does not have a happy ending in reality. We got the construction cartel, and just to make certain that you don't get the feeling the lonely idiots get victimized by cartel, one of the victims in the construction cartel is actually the University of Copenhagen Faculty of Law. I uncovered that a couple of days after I had been on television saying that only idiots got victimized by cartels, so obviously I was wrong about that. We got a case right now about wholesale electricity, which is also a very malicious cartel. So we have cartels, but not as many as the media like to suggest. The second misunderstanding is that it is profitable to engage in a cartel activity. It can be, but it is not necessarily a rational, cautious, malicious decision to do that. All the slides will be available subsequently. You don't have to make notes. Oh, you're a law student? No. Oh, okay. I love when a law student makes notes. Now, the third misunderstanding is that the cartel is the outcome of a shady negotiation process that has taken place in a dodgy room. In the Lucene cartel, they always met at luxurious hotel. So, cartel can also happen at beautiful places. But it is a misunderstanding that the cartel is the result of shady negotiation in a dark room with gentlemen smoking cigars. Can happen, but sometimes also women are involved in a cartel. Now, cartels can be profitable. I'm not really qualified to evaluate if that always is the case. My perception is that a lot of the times it is not that profitable at all. It's more a question about reducing losses and stay in business. But what most people does not understand is how unbelievable complex it is to run a cartel. And you don't have to take my word for it. You just read this book. It was an eye-opener reading a book where the author goes through all known cartels in Europe and US, explaining how cartels operate and why they almost always collapses by themselves. Just imagine that you try to set up a Christmas gathering with some old friends. It's a nightmare coordinating all these calendars. And it is the same when you have to or want to establish a cartel and you want to prevent it from collapsing. So most cartels actually collapse by themselves. And once again, we can take the Lucene cartel, and here we can actually see how we have repeated price wars. Even though the cartel actually goes through all these years, nevertheless, they actually collapse by themselves, but in practice by themselves. Then they re-establish it. So running a cartel is just like having a relationship. You break up, then you make up, then you get married, then you get divorced, and then you get remarried, hopefully. Now, often we see them take proactive steps. In the movie, The Cartel, we had a muscle man, and it was not pleasant having a meeting with him because he showed up if you failed to respect the quotas, and he was actually quite physical. So, you know, one way of maintaining a cartel is to have an enforcer, in this case, a quite violent man. In the Lucene cartel, we did not have an enforcer, but we had a trade organization and we had periodical meeting. And if you, I don't think it is in a movie, but if you see the Lucene cartel on YouTube, you will see how some of the participants threaten each other with beatings. I don't necessarily think it is serious, but there is a perception that if you do not respect what we have agreed to, you know, if you fail to meet the quotas, if you drop the price, you know, I will retaliate. So, you know, in order to stabilize the cartel, you need to have somebody who enforces it. That can be a muscle man, but it can also be a ringleader or a trade organization where you meet periodically and you talk about the cartel businesses. That means that when you draft a compliance program, when you do internal compliance meeting, you know, when you talk to the salesperson, you always talk about don't go to a meeting without a clear agenda. Don't engage in discussions about things that is not the business of the competitor. That is, who is my customers, what is my price. That is the typical approach to compliance. And when I think back about that compliance program that obviously didn't work, I actually think it was stuff like that we put into it. We do not want to be part of a competition infringement. Therefore, we do not participate in meeting where there is no agenda. And that also means that when I lecture to my students, when I talk to lawyers, I actually recommend being very vocal if you get an invitation. You know, one of the, I generally don't recommend slamming people, but if you get invitation to participate in a cartel at a meeting and you slam somebody, you trash the chair, you destroy some things and you run, I am utterly convinced that they will remember it. And more importantly, if you're lucky, somebody will send you an invoice for trashing some furniture. And that means that when the competition authority shows up 5 or 6 years later, you on file do have an invoice establishing that you very clearly said, no, I do not want to be part of this cartel. This is the typical approach. This is the recommendation. I don't know, have any of you participated in compliance meeting with a lawyer and said something like that? Yeah, I can see one guy who's saying yes. So my point is that, you know, I'm spot on. And it makes some sense, you know, don't engage in activity that makes it plausible that you are part of a cartel, because if there is a meeting and if the price goes up, the enforcer is going to look for that. But just because there is a statistic overlapping occurrences does not mean that they are linked. You know, in case you do not know it, there is a perfect correlation between the career of Nicolas Cage and the number of people who's drowning in swimming pool in US. Full disclosure, I have not checked it, but I am utterly convinced that there's no link between those two facts. But it is obvious to everybody that if there is a meeting and then everybody raises the price subsequently and you do not have a real good explanation, the most plausible things that will come to the mind of the enforcer and the judges supervising the case many years later is you probably agreed to something that is anti-competitive. And here it comes handy if you have that invoice establishing that you said no. Now, that also means that enforcers look for suspicious pattern. And now I'm looking at you. Isn't that correct? Yes, you look for suspicious pattern. And I don't know about you, but if I was group legal in a company, I would also look for suspicious pattern with my suppliers. Does the price suddenly goes up with my suppliers across all of them? Because then potentially there might be a cartel and I could be a victim of it. So that means that company and enforcer look for suspicious behavior. And that is, of course, the reason why, you know, there is a meeting, the price goes up, the plausible conclusion is they have probably colluded. So we all naturally adopt approach where we look for certain things that look suspicious. That is not only that the price goes up, but it's also that only certain companies bid. Now, I have a friend who is a judge in a very remote area in Denmark, and he kind of noticed that when they have forced sale, mandatory auctions of a house, the local bidders never compete against each other. Only one shows up. He had once tried that two showed up and then one disappeared. He is utterly convinced that they have colluded. And on balance, I think that is plausible. And one day I might actually read in the news that local cartels between real estate developer has been busted. So it makes some sense to look for suspicious pattern. The problem is that you should be careful investing too much energy into it. Right now, I have seen a lot of suggestions saying, well, why don't we deploy artificial intelligence screen? Does the competition authority do that on Færøerne? No, not yet, okay. The Danish competition authority claim that they have an algorithm that are screening for cartel. They put out a press release. Then I had a meeting with them, and to be honest, I think that they are probably I think they are presenting it more advanced than it is, but they have an algorithm that screens for suspicious bids, including non-bidding. I've seen a couple of big companies putting out identical press release. So my perception is that a lot of companies and enforcers has an ambition of having an algorithm that automatically screen for cartel, and that makes a lot of sense. Because there are cartels out there, but we need to deal with a couple of misunderstanding and misconception. And one of them is that I don't think that there are that many cartels at the end. Now, once again, I'm a little biased because I was also in private practice for many years, and across all those years, I never had a client who was guilty. There were some who was accused, but of course that was malicious and false. So I'm biased, but this is the figures. And what we can see is the number of cartels busted by the European Commission actually drops, and they keep dropping. In reality, if we go much more closer into the figures, we will actually see something much more dramatic, because what we can also see is that even though not only do we get fewer and fewer cartel decisions, more and more of them is actually not real decision. It is settlement, where you get discount for admitting and cooperating. So it looks a lot like the area of big evil cartels are, I wouldn't say over, but we see fewer and fewer of them. Now the enforcers are not really willing to admit this, but I have seen a lot of strong evidence, because they talk about we need to focus on abuse of dominant position. The European Commission are so happy that they got a Digital Market Act, because that means that they do not have to lay off anybody. They can just reshuffle them to other areas. So I think it's safe to conclude that there are strong evidence that are fewer and fewer cartels. They are still out there, but they are fewer than they used to be. Now we can also go into Danish practice. I have identified almost 900 anti-competitive agreements, but only some 14% of them were so aggravated that fines was warranted. Now there are some certain reservation in those cases, because traditionally we didn't issue fines, so it's more recently, and there are some overlap. But the picture is that even though there's a lot of infringement, very few of them are obviously, heinously cartel infringement that you really warrant, the full Monty. And a lot of them is actually vertical cases, retail price maintenance clauses, and the economists would say, what's the problem? But we lawyers think that retail price maintenance clause is a problem, and of course, always the lawyers are the bosses. Now, let me give a couple of examples of some cartel infringements where I really, really don't see, well, I see the infringement, but to be honest. One of them is, for instance, the Association of Danish Undertakers. They had a ban on using advertisement. I don't know about you, but when I get home from my work, I'm really tired. Sit down on my couch or turn on the television. I do not want to hear about the service they're selling. That's not what I want. So personally, I fail to see the problem of not allowing them to run advertising for funeral services on television. I accept it might be anti-competitive. I'm not even certain it's anti-competitive, but I accept it. But I don't really think that is a cartel. Another example is the Association of Retailers wanted to fight youth obesity, and therefore they had concluded a codex about don't place candy at the height of kids' hands up at the cash registrator. Okay. I can see the problem, but once again, it's not really a hardcore cartel. So the point is that if we focus too much on traditional heinous cartel, we get a misalignment. What really should worry compliance officer is the cartel nobody wanted. I will touch upon 4 examples of how you can end up in a cartel infringement in a situation where that was actually not what you intended. You ended up in a cartel infringement, just like my girlfriend gets sucked into a shoe factory, a shoe shop. One of them is, for instance, the Danish disco cartel. That is a really funny case because it involved a lot of small nightclubs scattered all around the peninsula of Jylland. And they have concluded a joint cooperation agreement where they would, train staff, doormen, waiters. They will also buy alcohol. And then they have also concluded a non-establishment clause. So they could not establish themselves with new nightclub in an area where one of the other ones had occupied. The Danish Competition Authority identified this as a heinous evil cartel that essentially is separating the market. It is pending right now. I don't see an infringement, but obviously that was definitely not the intention. There was a legitimate idea behind why they did this agreement, and then there was included something that was anti-competitive. I don't think it is anti-competitive, but that is the position of the Competition Authority. It will be exciting to see what the court say about that. I have an article, Murder on the Danish Floor, which I think is quite funny. I will make a reference at the end. Now, to understand why something that does not officially look like a cartel nevertheless can be identified one, we need to understand that if we go into Article 101, and is it also paragraph 6 up here? Yeah, paragraph 6. It says anything that has the object to restrict competition or the effect to restrict competition. And an object instruction is anything with prices or market allocation. Now, non-establishment contract or clause is not on the list. Nevertheless, the Danish Competition Authority said that it was an object infringement, and that is because it includes surrogates. So it is not only price fixing agreement or market allocation, it is also clauses that indirect brings this about. Object infringement is just simply anti-competitive per se. It's just like if you play Monopoly, go straight to jail. If it is only anti-competitive by effect, you have to establish counterfactual. I don't know how the world would look like without McDonald's. It would probably be slimmer. But I think a lot of us actually enjoy McDonald's when we're traveling with kids in a country that generally had bad hygiene, because there's nothing that can destroy a vacation like everybody has to go to the toilet. So if you go to McDonald's, you do actually get food that has been processed correctly. Or if you go to a country where they don't speak English or Danish or Faroes, you just point and you get something you appreciate. So on balance, there are pros and cons about McDonald's, and we only see it as a problematic thing if a counterfactual sees a problem. Now, as I already said, if it's a surrogate, something that indirectly facilitates a price coordination or a market allocation, that would be anti-competitive by object, and that is what happened in the district case. Personally, I don't see an infringement, and I very much look forward to see the case going forward. What do we do about that? Well, I think the prudent approach is that whenever you have contracts with competitors, include your lawyer in the discussion. He or she will happily review the contract and hopefully identify anything that could be contemplated and seen as anti-competitive by object, and thereby result in you ending up in a cartel. Now, of course, lawyers can make mistakes, but then at least you have somebody to blame for it. I don't know if it gives you a discount when it comes to doling out the fine, but perhaps. Another classic example is group-associated companies. Carlsberg has been involved in a cartel in Germany. They claim, which I actually think is correct, that first of all, they were not actually involved in it, but it was subsidiary, and it was a salesman who probably overstepped his authority at a meeting. I don't want to pass judgment about what exactly happened, but it is indisputable, but it was not Carlsberg Group who engaged in the infringement. It was a subsidiary, and I even understand it was a subsidiary that they acquired, so it wasn't even a Carlsberg subsidiary at the time of the infringement. But the fact is that the newspapers love writing about companies like Carlsberg engaged in cartel activity. Carlsberg is a big company in Denmark. I'm utterly convinced that almost no matter what company on Færøerne who get accused of being part of a cartel, the local press would love writing about it. So, if a subsidiary engaged in something that even remotely looked like the cartel, the press would love writing about it. And you might get acquitted in 10 years, you might get a fine, but your reputation has been damaged. So what you also should be concerned about, what happens in subsidiaries. This is where I've been thinking a little more about it, and I have looked into a lot of papers, and I've talked to a lot of group legal in-house lawyers. What they say is that technically there are certain factors that makes it more plausible that a company will engage in a cartel. And that is that the salesperson knows each other very well because they are rotating. It is very difficult to establish the level of trust that makes it possible to conclude a cartel agreement. But obviously, if you know each other from Rotary or the local football club, or you have worked together, it is much more easy to establish the level of trust. So if you have a situation where you see a lot of people rotating between you and your competitor, that is what we call a plus factor. Another one is an incentive program that incentivizes the management to take short-term gains. Because cartels can be profitable, and the problem will not really emerge until a couple of years, and then the CEO has left. So there are certain factors that increase the statistic chances that a subsidiary engage in a cartel. You can also deploy screens, because if suddenly one of the subsidiaries is extremely profitable, that is an indication there's something wrong. Now, we have a bank in Denmark, Danske Bank, who was involved in some laundering of money with some Russian connection in a subsidiary in one of the Baltic states. One thing I noticed was that there was actually a warning sign, and one of the signs was that this local subsidiary was very, very profitable. The media used this to say, well, the reason why you didn't stop it was probably because it was very profitable. Personally, it was probably because they didn't notice it, but they should have been aware. Why is this subsidiary suddenly so much more profitable compared to everybody else? So if you are group legal, if you are a lawyer for a company, and you certainly see an unexpected spike in profitability in a sector, in a subsidiary, in a activity area, that could be a warning sign that there might actually be something going on in that area. And then you should look into it. There might be legitimate explanation for it. You might not have the management resource to do it, but there's definitely something you can look for. So it does actually make some sense to have screens, not only to avoid being victimized by cartel, but also to avoid that you have some rough management or salesperson subsidiary who choose to engage in a cartel. A third way of ending up in a cartel is what we can say careless, stupid comments that can be misunderstood. Now, this is actually a real cartel, the T-Mobile cartel in Netherlands. There was one meeting between sales representative of different telecommunication operators, and here they discussed, I think it was remunerations of sales organizations and margin. You know, there was one meeting and one very short discussion about things they shouldn't be discussing about. And everybody participating in that meeting was most likely part of that cartel. So that means that we are here today, and if some of you in the corner start discussing things you shouldn't be discussing, everybody at this meeting would be suspicious and subject to potential investigation, you know, for years, and hopefully we will get acquitted, but we would have been ended on in a case that we would not want to be part of it. So careless, stupid words, sentences that could be misunderstood. And I have an example from Denmark that is a horrible case. That was veterinarians who had a meeting. This is the summary. And in that summary, there was some wording that could be misunderstood as, we want to collude on prices. So that all those participating in that meeting became subject to a criminal investigation. They actually got convicted at the lower court for being member of a cartel. They got acquitted on appeal because it was uncovered that what they had discussed was not to collude on price, but that was to make certain that there was access to veterinarian services on Christmas and during weekend. And how do we refer to each other? Because the problem was that if I was on vacation and I sent you as a good customer to this gentleman over here, he would have a strong incentive to overcharge you because, you know, he would never see you again. And, you know, I would get a bad reputation because why did you refer me to a cheating person, right? So obviously we had an interest in discussing in advance that if I referred the customer during my vacation, what would you charge him? So here we have an example of they expressed themselves in a manner that could be misunderstood. Luckily they got acquitted, but it wasn't until they had been subject to appeal, and at that time they had been dragged through the media, you know, being portrayed as, you know, heinous cartel member. And that was in an area of Denmark where everybody knew each other. So obviously, you know, I don't think it was very pleasant to go out shopping and then, you know, people look at you, you know, you're a member of a cartel. And I would imagine the same would be the situation up here on Færøerne. We do have a most recent case that actually provide a little more guidance on what you can talk with your competitors about. And what essentially is saying is that don't talk about the future. And I'm not talking about future contract. I'm not talking about future concerts and, you know, New Year's, Christmas. You know, I'm talking about don't talk about future prices, bids, customer allocation. You can talk about the past because the past is normally not guidance for the future. But if you can extract anything from the past that offer guidance for the future, that is also a no-go. So the bottom line is that don't talk about things that is really not of your competitor's business, and that is of course how I run my business and how I price my services. I think much can be attained through targeted training. You know, if you gather your sales organization and explains why it is so unpleasant getting dragged through a cartel investigation, I think they will understand it. And I also think they have a pretty good understanding as there are certain things we do not discuss with our competitors. That is my prices, who we bid for. Of course you can talk with your competitors about, you know, the government. young people being lazy, present company excluded. You can talk about general things. You can also talk about what is the trend in the sector, but you at heart typically have a pretty good idea about what not to talk with your competitors about. And you can also add in, should it happens, don't necessarily trash things, but come back to me as fast as possible. And we have, way of getting. Do you have leniency up here on Færøerne? Not yet. Okay. So the point is that if you turn on your co-conspirator and go to the competition authority, you will get immunity and discounts. And I have never had such a case because I've never had a guilty client. But most lawyer tells me that it is an unbelievable pleasant experience showing up at the competition authority, telling about a cartel they know nothing about. You'll get complete immunity, and when you leave the competition authority, who do you think you meet at the waiting room or the lobby? The other cartelists, right? They know they are toasted, and you get immunity. So targeted training where you tell your sales organization is, of course you can meet with your competitor, but don't talk with them about things that are not their business. And if you feel that you might have said something you shouldn't say, come to me. We can get out of this cartel infringement. You can also send a letter to the competitors saying that it was a pleasant meeting, just to avoid any misunderstanding. I do not want to be part of any kind of coordination or whatsoever. Once again, if the cartel comes up, it's not a get out of jail card, but it does actually look quite mitigating. Trade organization, that is the typical way of ending up in a cartel, because the trade organization typically serve a lot of legitimate reason. They benchmark, they coordinate, they negotiate, but they can also act as enforcer. There are even some who have suggested that in practice, you cannot run a cartel without a coordinator because they will collapse. So you typically see trade organizations serving a dodgy role in cartel, but trade organization can serve a lot of legitimate reason. You just have to be careful what you get them involved in. And no, deploying artificial algorithm to coordinate is not an excuse. There is a couple of cases pending in US where algorithm has coordinated, and that is not a legitimate reason, at least not in Europe. If you go to trade organization, just make certain that any information you share pertaining to internal information for the purpose of benchmarking, improving, etc., make it old, make it so you cannot identify who's actually the sharing, and put in a third person. If you do that, it should not create an infringement. So in conclusion, rather than focusing on the false idea that cartels is something you intentionally enter into, it happens. Most cartel is something you end up in, and that means that there are certain steps you should take internally, and that is, have your lawyer review contract to prevent restrictive covenants. Look at the management remuneration programs in subsidiaries, and be a little careful about what you share when you go to a trade organization's activity. Now, I have listed the resources I have relied upon here, and as I have what I believe is a very excellent and funny paper, I've even thrown in that. And I would be happy to take questions now, and I'll also take questions subsequently on my email.
Det bara köra handen upp hvis det har en spurning, och kan alltid omsätta alla, alltså hvis det vilja springarna förskon så kan ni alltid omsätta för det. This might be a little bit reiteration. I can start out by asking a question, but obviously an email will rarely state, join this cartel, or come commit crimes with us, so what do you look for when you get an email from a competitor that should spark question marks in your head, or warning bells in your head?
I really love when lawyers contact me, and I'm always willing to discuss without going into names, etc. But sometimes lawyers actually send me emails like that. A client forward me an email, I send it to you, and it essentially said, why don't we meet and talk about the prices to a customer? So you do actually have emails where does people really write that? Now, what quite often happens is that a cartel is something that is secret. So when the enforcer try to bust a cartel, they know that there has been coordination. They know there have been one meeting. They think there have been several meetings. They have a couple of emails. So they have a mosaic, a lot of clues, just like when you have a police investigation. So what you're asking, what do you do as house lawyer, group legal, when you get one email? Well, the first thing you have to establish is this just one email, or is there several emails that I have not seen? So you should of course ask the person, is that something that has happened before? Or do you think that there is something going on? And I think that is the first approach. And if you have one email, I cannot see a cartel be built on one email sent to you, which you didn't even reply. But obviously, you don't know if there are more. That is what you need to figure out, because if there are more, there might actually be this cartel. And then you have to make a decision, do we ignore it? Or do we go to the competition authority and get leniency and immunity? And that is the decision you have. But I would definitely recommend, don't panic. Start by figuring out, is this just one email, or do we have a whole trunk of email? Because sometimes you might see one email, but there might be 10 or 20 out who's much more incriminating.
I guess as a follow-up, if the questions are that simple, usually when they're presented to you, what do you think that stems from? Do you think it just stems from ignorance of competition law, and how do you fix that problem, sort of society-wise?
Yesterday, when I arrived here, I watched some television, and I actually love National Geographic. And one of the things I really love is when I have this why does plane drop down accident, and I'm so much surprised how stupid pilot acts. And when you see a movie about criminals, they're really smart. But when you read the police report and really see what happens, most criminals are unbelievable stupid. And it's just, there is a mastermind who gave them a mobile phone. We only use this mobile phone to coordinate. Most criminals call their girlfriends on that. And that, helps police a lot. So my point is that my feeling is that most cartels are established by people who don't really care and know nothing about this. But we see a drop in cartel, and there's two possible explanations. Do we have fewer cartels, or have they become much more clever? I cannot rule out that they have become more clever, but I tend to describe that most cartelists, they do this stupid thing. And that means you can typically identify them based on so simple emails. But please remember, there might be a benign email saying that, by the way, it was a very pleasant meeting. What meeting? And then you should be, was there a meeting? Right? So, you get an email that, look very suspicious, but you can also get an email that's, what's this is about, right? And that is what you have to look for, because is this just one clue of a much larger conspiracy, or is there nothing to panic about?
And I guess the second part of my question, how are we to fix that issue? Are there not enough courses on this in economy classes, or?
I asked a lawyer, and he said his best client was actually the competition authority, because whenever they busted one cartel, 10 companies called him. I think definitely something about awareness. But I think most company has an idea about what they're allowed to do or not allowed to do. So I think that the time of traditional big cartel is over. We have a lot of small cartels, because there are so many areas at the economy where everybody knows each other. And in such a situation, you might have an incentive to collude. But that is something we have to accept. And I think, I'm not saying that I can live with small cartels, but you know, if we can bust all the big ones, I think it has helped a lot. You know, I know we have a lot of lawyers here. Has any of you ever been involved in something like this? Or nobody wants to? Nobody wants to share it. Okay.
Everyone has innocent clients.
Yes. Yeah, I know that feeling.
Well, I can ask a question then. I was thinking about you talking about the cartels collapsing by themselves mostly, and the familiarity increasing the risk of creating cartels, familiarity between people. Do you think this would increase cartel chances in the Faroe Islands because of the small markets and the degree of familiarity?
I don't want to say anything unfavorable about Faroe, but I think I have some family from a very small island in Denmark, Læsø. I was too young to remember it, but my mom always talked about it. We were visiting some relative up there, and we went into a fishery shop and bought some fish. And then later we met the salesman, and he actually panicked because he realized that we had family, so he just cheated us. So I think that the fact that Faroe is very small has pro and cons. I think that it increased the chances that people know each other, and that makes it more likely that they will engage in cartel activity. But I also think that the social consequence of doing is so much more inflated here. I'm from Copenhagen. I can disappear. But here everybody knows each other and are related. So if I do something that is considered unacceptable here in Faroe, I would be out of business. So I think it increases the chance of you might collude, but it also increases the consequences of doing it that can actually dampen it. So it goes both ways. So if I should be statistically based on my own experience from Læsø, if you collude, it would be more likely you collude against somebody who's not local. That could be me.
Did I understand you right that you don't consider the non-establishment clausule?
Yes. Yes, I think that the decision is incorrect, and that is based on the fact that what they had agreed to was about joint training, and then they had agreed to something that might restrict competition on a separate market. So the anti-competitive restriction was not on the market where they have done the agreement, and therefore do not think it qualified as a non-compete, object restriction. So I disagree on the decision, and I'm so much looking forward to the case go forward. So I think the decision is incorrect. It is entertaining, but I also believe that's incorrect. We could also add other things. If we go back to the establishment, there are almost 200 kilometers between some of the nightclubs, and they are obviously not competitors. I can tell you a little more about that case because I have heard a rumor, which I believe is true, that there was actually originally it was between some nightclubs. Some have been sold, and I think that the lawyer who made the sale probably made a mistake because he didn't file for leniency. Some got leniency, so the lawyer probably made a mistake. And there was also an asset transfer agreement that didn't really account for the fact that there might be some antitrust liability. So once the civil case is over, there will be a criminal case, and then there probably will be a case against some lawyers who have made some mistakes. So I suppose if you go to prison, you take your lawyer with you. That's nice.
We've talked a lot about how one can accidentally commit cartel infringement. If we go to abuse of dominant position, what do you think is the most prominent reason why those sorts of infringements happen?
In Faroe, I didn't know I was dominant.
Yeah.
There are, Færøerne is an interesting economy, but it's a very small economy. It is very open, but in some aspects also very local. So that means that you do not have to be very big to be dominant in the Færøerne economy. So I think the typical explanation for a company engaging in a new dominance, I had absolutely no idea I was dominant. That come generally as a surprise to me. Then there are other companies who are struggling, like Post Denmark. They're really struggling to accept the fact that their business case is dying, and then they commit some anti-competitive act. And then there are companies who just simply fail to understand and accept the rules. Could be Google. So there are different motives, and of course there are also companies who are evil and malicious, but most companies don't understand that they're dominant, and they don't understand that what they have done could potentially be anti-competitive. And then there are also certain forms of abuse that are so legally complicated that it is virtually impossible to find anybody who can tell you what to do and what not to do. And in such a situation, okay, I have to make a decision. And what should that be? Well, I say no, I say yes, and this is my price. And then you accidentally infringe it because nobody can explain what you're allowed to do.
And how does a company guard themselves from that sort of situation?
Many years ago, I helped a lawyer evaluate if a company could engage in certain pricing practices. Their position so far had been that they were dominant, so they didn't offer discounts. But that became progressively commercially unsustainable. So they wanted to have a mapping to which extent were they actually dominant and what was the possible lowest price they could offer. So I actually helped them evaluate that. So one thing of doing is, say, okay, we just have to accept that we might be dominant. So we just simply always say yes, or we always say no. That is the prudent approach, but obviously that is commercially suicidal. So you will have to make a decision. Do I hire a lawyer, an economist to map if I'm dominant and what my price benchmark could be, and then I have to pay a gigantic fee for that? Or do I take a chance? And to some extent, the chance can be okay. As long as my price does not go below the competitors, that cannot be predatory pricing. So, you can also do, okay, I might have to accept the fact that I'm dominant. What can I do to reduce the risk that I engage in certain practices? I don't know about the competition authority up here, but at least in Denmark and the European Commission are always willing to have an informal discussion. That could also be a way of doing it. Yeah. What you should not do is, of course, to invite your competitor to a discussion and then agree on the price, because then it would be collusion.
I don't know, you talked about trashing the hotel room to show that you are innocent, but there are also provisions in the competition laws in Denmark and Faroe where you can ask the authority both whether you are a dominant player and also if your behavior is in breach of the law.
We used to have the same system in Denmark. You could simply apply for I'm not dominant application, but that got abolished. But I know the Danish competition authority sort of have a policy, if you show up with a lawyer and prepared, they will always have a discussion. And I'm quite convinced you have the same up here. And I think that is the right approach. Obviously, you have to be a little careful about, saying anything too clear, because then you will, you might not be able to investigate it subsequently. But I think that is one way of dealing it. I think I might be dominant. How can we figure out? Well, you can ask for the competition authority. If I'm dominant, this is probably what I should refrain from doing. So you have to make some kind of risk assessment, and I think that lawyers can typically help you with that. And if you're a lawyer, I'm always willing to discuss on a non-name basis. I never charge people for it, and I really love the opportunity to hear some real example, and some of them are entertaining, and some of them are just, we don't talk about that. Is it time for lunch?
Ja, hvis det ikke er spørsmål, så hadde jeg skulle gjøre noen større hånd.